Hello, and welcome to today's webinar, The Anatomy of a Privacy Policy. I'm Christine Kulamani, staff attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. First, I want to start off by thanking my colleague Lauren Paley, who isn't on the line today, but has done lots of behind the scenes work to make today's webinar technologically possible and advertising it. Also, I can't not give a tremendous thank you to our presenter, Shahed Kader, managing attorney at Kader Law and a small business owner himself. So double expertise we have with us today. Before we jump into the content, I want to go over some logistics for today's webinar. First, if you're joining us live, this webinar will be recorded. To access the recording, we will send out an email copy to you. We also ask that you please complete the post-webinar survey. In addition, you have access to the presentation slides right now under the Handouts tab of the GoToWebinar control panel. If you have questions as we go through the presentation, please send them to us through the questions box in the GoToWebinar control panel. As we go and after the presentation, we'll try to get to as many relevant questions as we are able. Okay, so we have all seen privacy policies on websites. Sometimes maybe we actually read them. But when you're reviewing or developing a privacy policy for your business, close care is required. We can't just skip over things and hope for the best. On top of having a privacy policy at all, it's really important to make sure that it's well crafted and has important essential components. And with that, I'll turn it over to Shahed to walk us through what the anatomy of a privacy policy looks like. Thank you again.
All right, awesome. Thank you, Christine, and thank you to the DC Bar Pro Bono Center for hosting this webinar. Once again, my name is Shahed Kader. I am managing attorney here at Kader Law. Our practice focuses on helping software companies specifically with their transactional needs. So when we draft documents, when we negotiate deals, when we put together things like terms of use and privacy policies, that's exactly what the practice does. Once again, this webinar will be the anatomy of a privacy policy. Quick note as we get started, nothing in this webinar, slideshow, or presentation is to be taken as legal advice. If you are seeking legal advice, please contact your attorney. That's the best way to get information here. If you'd like to learn more about me, you can find me on LinkedIn, Shahed Kader. Also, our website is www.kaderlaw.com. We're licensed to practice in Washington, DC and Maryland. So as we get started, the first thing I want to talk about is a privacy policy. What is it? Basically, it's a statement or a legal document that discloses some or all of the ways that a company that collects information, gathers, uses, discloses, or manages information that they collect from their website. So this information can be anything that can be used to identify an individual. So if you have a contact form on your website, if you have a web application that you have, or a website that is a software application or software as a service application, and you're collecting data like where is someone located, advertising cookies, if you have ads on your website, privacy policies definitely apply to you. And so what's important to note is that the applicability of a privacy policy is not the same as a terms of use or a terms of service. Terms of service, terms of use, that's kind of like the legal document that governs what someone can do versus what someone cannot do on your website. A privacy policy is a completely different document, a completely different agreement, essentially, that you're having with people that are entering information on your website or even visiting your website about what they're physically giving you, the information that they're physically or actively giving you through forms, through anything like that, or through automatic data collection. So once again, there's two different things. I think a common question that we got leading up to this was, can you just download a privacy policy online and stick it on your website? I mean, of course you can. And you can find privacy policies pretty much on every single website, including mine on kaderlaw.com. But the thing is, there's two things that you have to think about. First is the applicability. Not every privacy policy, even terms of use, not every terms of use or terms of service apply to every type of business. So if you're just copying pasting from something else that has nothing to do with what you do as a business, you're putting yourself up, you're opening yourself up to a little bit of liability in terms of what can be done on your website, what kind of information you're collecting, what's actually implemented into it. So the short answer there is it's not best practice. It's not recommended to just copy and paste from another website or another source to do that. Also, one thing to note about privacy policies as to whether, what the practices that you're saying in the privacy policy, we're going to go through what actually goes into a privacy policy in terms of, what each section, which are best practices. But one thing to note is if you're saying you're doing something, you should be doing it, right? Don't put anything in your privacy policy that is just general language that you're claiming to do when you're not actually doing. That's going to set you up for a problem as well. Right now, one thing to understand from a legal landscape, there is a lot of data breaches going on, and you'll see that there's a lot of rights and laws and regulations that are coming out state by state regarding privacy, and you'll see that specifically. This is DC Bar Pro Bono Association. Virginia just recently passed a Data Privacy Act. California has one, Colorado has one, and I believe 27 other states have acts that are either in Congress, in their state Congress right now, about to be passed or coming along that way, DC included. So, based on that, it's important to understand that it's not just something that, this is best practice kind of thing. No, you're going to be legally required to have a privacy policy, a privacy notice, and B, actually do what you're saying you're doing when it comes to these privacy policies. So just keep that in mind. If you're collecting information online, if you have a contact form, if you have a web-based application, if you have a software application, and you're collecting this data. So without further ado, let's talk a little bit about the sections that actually go inside a privacy policy. One thing to note is I'm just giving you a high-level overview. This is not a end-all, tell-all. This is not legal advice. This is not what absolutely needs to be in your privacy policy, but this is just a general idea of best practices of what should be in that privacy policy and what each section specifically means. Now, I won't be able to tell you what your business specifically needs to put in that section based on what you're doing, but I will give you an understanding of what each section is about. So generally, the first section is an introduction and definition. So this introduction section of your privacy policy should let your users know how this privacy policy does, how this privacy policy does, what it does, and how it does not apply to users. It's going to set up a contractual relationship between the two of you, between you and and it will tell the users to take the privacy policy as seriously as you take it. This section should also define the terms used throughout the policy, including what is considered something like personal data, what is confidential information, and so on. There should be an acceptance section as well. This acceptance is essentially saying that, hey, by clicking I agree or by using our website, you are agreeing to this privacy policy. So you need to understand what exactly is in here. Next is the age consent. Depending on the state you're in and the content that you publish, your privacy policy should set forward an age limit for use, such as our website is not intended for children under the age of 16. The last thing you want is to fall into different type of privacy regulations where it could be claimed that you're marketing towards people under the age of 13, and now you're subject to different laws. Just so you know, just so you understand the landscape, there are a lot of privacy laws out there, and there are more coming. Like I said, there are state-specific privacy laws coming out. There's also federal laws like the Children's Online Privacy Act, which is COPPA. So if it's a child under the age of 13, there needs to be some level of consent coming into place from a guardian or something like that. There's also FERPA, which is federal education related. If you're a healthcare organization like a doctor's office or something like that, HIPAA definitely comes into play, and you need to have a completely separate privacy notice regarding HIPAA if you are governed or subject to HIPAA regulations. So just keep that in mind. Next, you should clearly lay out what type of information you are collecting. So use this section to identify what types of information you're collecting about your user, the categories it falls under. Identify the information provided to you by the user and the information that you collect through automatic means like cookies, traffic data, web beacons, location data, etc. So what does this mean? So if you have a contact form or something where people sign up for your service, if you're a software as a service application, that's what you're collecting, right? The form is name, address, telephone number, email address, whatever it is. That's all personally identifiable information. So you need to clarify that this is the type of information that we're collecting. But over that, a lot of you that have websites, a lot of you have things like Google Analytics. So your marketing company or even you personally can kind of analyze what kind of traffic you're getting. Where are people coming from? Are they coming from Washington, D.C.? Are they coming from Maryland? Where are they landing on your website? That's all considered information that you collect, even through automatic means. That's using cookies. That's using traffic data. That's using web beacons location data. If you have advertising on your website, so say you're a content website, you're building content, or you're an online magazine or something along those lines, and you have advertising, those are definitely considered, and that should be mentioned in your privacy policy, that you have advertising cookies in here, because a lot of advertising right now tracks people through the internet, right? So if you see something, say you see something on Amazon, go 3 websites later, it's still showing up in your ads. That's what these tracking cookies do. It's kind of scary, but that's exactly what's happening. And your privacy policy should clearly lay out that, hey, we have advertising and there's advertising cookies in there. And that's where the third-party use of cookies and other tracking technologies come into play. If you have advertisers or ad network technology, third-party tracking apps in your code, use this section to let your users know about how they are used for your particular website and business. Next is vendor management. This section should outline how you hold your vendors and third parties to data security standards by agreement or audit. This is more applicable to things like a software company that has a lot of third-party vendors in place, but it could also be applicable to, if you are a restaurant, for example, and you have a booking system or reservation system built into your website. That reservation system is obviously collecting a ton of data, whether it's Resi or whether it's OpenTable, whatever it is you're using or implementing into it. So, when you have these integrations, obviously they're going to give you boilerplate language and their terms, and it's going to go off their website. But at the same time, you need to disclaim liability in a way where it says that, hey, there's a third-party vendor over here. We have nothing to do with this reservation. All we're doing is we're going to sit you at the table once you get here. Same thing if you have a salon and one of those booking apps that you have in place. So vendor management essentially means that you are going to say that we're using third parties and we are holding them to certain standards. And it's harder for a small business to kind of really monitor versus a bigger business, monitor what their vendors are doing. But this is kind of the future of where data privacy is going. You need to have an understanding and keep track, at least do some level of due diligence with all these vendors that you're going to be using to facilitate your business, to make sure that they also have privacy practices. Because like I said, the last thing you want is for you to be liable for a data breach on their end. Next, once again, these are things that apply more to software companies. If you're building a piece of software or a software as a service, de-identification standards. So if you are collecting data in an aggregated manner, meaning things that's anonymized, de-identified data, and that's Google Analytics, that's what it does, right? We don't know who it is visiting us from Washington, D.C. We just know someone from Washington, D.C. is visiting us. This section defines any standards you've implemented for de-identification or anonymization or pseudonymization of data. This is probably not applicable to a small business, but if you do have integrations with other kinds of things, like your reservation system, like your booking system, this might be applicable. And then there's industry-specific section. So, like I said, if you're a medical provider, a doctor, or a pharmacist, a pharmacy, or anything like that, you have a website and you're collecting information to deliver goods or services or whatever it is, even book appointments. Your industry may have specific requirements. If you're in healthcare, you have to follow HIPAA, Health Insurance Portability and Accountability Act. If you're in finance, consider SOC 2 regulations. Not necessarily applicable across the board for small business owners, but this is something to keep in mind because based on the industry that you're in, there might be some applicability over here. There might be extra rules and regulations that you apply. Governance section generally outlines how you internally govern your data privacy standards, including the use of a data privacy officer, a third-party compliance standard. This is something that, once again, it's applicable more to software as a service organizations or software companies, technology companies, but it can also be applicable to a small business, in that you need to keep in mind, hey, do you have somebody internally or even an outsourced company that's handling how you are approaching information security, how you're approaching data privacy, how you're protecting the data of the customers that are coming to your website or entering their information, and maintaining all of that. Next is how you use the information. So in addition to telling people how you're collecting data, you should be telling people how you're using the data. So use this section to let your users know, your visitors know very clearly and in plain terms how you're using the information and data they are providing you with, and what legitimate business or legal purpose this serves. So for example's sake, if you're simply collecting someone's information, their name, address, telephone number, so that you can call them back, you can write that. You could say that, hey, we provide a service, you requested information about our business, we're just going to call you back. That's the business purpose, and we have consent from you because you entered into this form. We have consent from you to actually reach out to you and let you know that's our purpose and how you're using the information. If you're using the information, if you're collecting this information and then selling it to somebody else as part of your business model, that's a whole other can of worms that you need to approach, and you need to kind of clarify that we're selling your data, and that's the purpose that we're using it for. Ultimately, what people want to know, people that are reading these privacy policies and even regulators want to know, is that you're appropriately using the data according to what you're saying you're doing. This goes back to the initial statement I made. If you're saying you're doing something in your privacy policy, make sure you're doing it. Next is disclosure of information. So use this section to let your users and customers and visitors know that you may disclose the aggregated information you collect about your users to third parties, subsidiaries, vendors, along with law enforcement in case of a court order, subpoena, regulatory request. This applies across the board. How are you disclosing your information? Any business is subject to a subpoena or a court order if they're involved in a crime, or if they're involved in a potential crime or something along those lines. If they're under investigation, or someone that frequented their establishment is under investigation, or anything like that. So it should be clearly noted in your privacy policy that you may disclose your information to a court order or a government. But on top of that, it's also with these vendors that you're using. If you're using a booking system, once again, if you're using a reservation system, once again, you are disclosing the information of your customers with these systems, as they are meant to provide services, right? So the reason that you get these third-party vendors is to help you with your business, help you with your services, and facilitate. So if you're sharing personal information with any of these organizations, that's what you need to understand, is you need to let people know that this is who we're disclosing information to, what kind of information we're disclosing, and why we're doing it.
Coach Shahed, a
Yes.
question on that.
Mm-hmm.
Would it be necessary to, in this disclosure section, mention that it's being shared with, for example, a web developer or a marketing person, somebody that's a contractor for the business and maybe kind of looks at the information through the course of business, but isn't necessarily, using the data on its own?
Yeah, no, absolutely. Because, anybody that has access to this information is privy to that information, right? So, I personally, if I'm entering information into a contact form for a car wash company or whatever it is, I don't want their marketing people to have my information, or I would at least want to know that their marketing people also have my information for whatever purposes it is. So you don't need to necessarily strictly name out that, hey, this is going to be shared with XYZ Marketing Incorporated. But you should let them know that we have third-party service providers, such as a marketing company, and we may share this information with said marketing company. Does that make sense?
Absolutely. Thank you.
Cool. Next, this is a big part of the latest data privacy laws and regulations, is accessing and correcting information. So you should use this section and set forth ways in your internal procedures to let users know what they can do to contact you, or use built-in features of your website to contact and correct information you have about them. So, the way to think about this is data privacy regulations. What they want is they want to give users the right to deletion and the right to access their data or correct their data. So if I've ever entered information into your form And so and I need to have the right to reach out to you and say, hey, I need you to delete all my information. I don't want you to ever contact me again. I don't want you to email me. I don't want you to have any of my information, any of your databases. So built into your privacy policy should be this information, should be this disclaimer that, hey, if you want us to delete your information, email us at XYZ Corp or whatever email address you have. Or if you have a third-party system set up for this kind of stuff, do that. A lot of small businesses, what they're doing, especially with their marketing teams, is they're collecting the email addresses and they're automatically putting people into email marketing campaigns, into whatever it is that their marketing company has set up for them or their internal marketing team has set up for them, because they're thinking they have implied consent to receive this marketing information. So this is also stuff that you need to put into your privacy policy, like, hey, we are going to be using your information to provide you with marketing, and we're going to send you, you're automatically going to be signed up for a newsletter, so on and so forth. Best practices to get active consent, people actually click a checkbox to say, hey, I consent to receive marketing information from there. But on top of that, when people are put on these lists, that's what you have on the bottom of that list. You have an unsubscribe button. That unsubscribe button could be the way that you remove somebody from your list. But also they should be able to, in general, reach out to you and say, I don't want you to have my information. I need you to delete it, whatever it is that you have about me, and so on. That goes into the next thing, right to be forgotten. Data privacy regulations like the California Consumer Privacy Act, the General Data Protection Regulation of the European Union, the Virginia law that's coming out, they mandate that your users have the right to be forgotten. Make sure you clearly write that out, that your users have this right. Next is enforcement standards. So this section should outline what enforcement authorities you report to, if applicable. This is not always going to be applicable, but there are certain industries like financial regulation or financial industries that you would report to, and the standards that you are set to. So if this is applicable to your business, you can put in, these are the enforcement standards. Like, for example, a financial technology company would report to FINRA or whatever else it is, or a healthcare technology company would report to the Department of Health and Human Services. Next, you should have a section regarding changes to the privacy policy. This section lets users know that you reserve the right to make the changes to your privacy policy. The big caveat over here is you need to let them know if and when you do it. So I think everybody here has received an email in their inbox that says, we have updated our privacy policy. We have updated our terms of service. We have updated X, Y, and Z, either from Google or Facebook or Instagram or anything that you use on a regular basis. That notification is actually for a purpose. They're not just trying to be nice. They have to kind of legally do it based on some data privacy regulations and laws that they're subject to. And you're no different, right? So if you're changing your privacy policy and changing what you're doing with information significantly, you should have a way to update people on how you have updated your privacy policy. So change it, but also send them an email that, hey, we have updated our privacy policy. You've entered your information before, so on and so forth. Contact information. So use this section to let users know how they can contact you. If you have any questions or concerns or comments about the privacy, or even if they want to exercise their right to be forgotten, this could be a privacy at your website address, or contact at, or whatever it is, just a way for people to reach out to you should they have any concerns about your privacy policy. Thing to remember is, this is applicable across the board. So you need to have a way for even regulators to contact you should they get a complaint from somebody. Should somebody reach out to the Attorney General or Commonwealth Attorney in Virginia and say, hey, I have this business that's collected my information and they're spamming me left, right, and center. I need to complain, and you need to find them. They should be able to find you. Next is applicable only under certain circumstances, which I'm not going to get into, but if the California Consumer Privacy Act applies to you, if the GDPR, General Data Protection Regulation, applies to you, if you're handling data of users in California, European Union, or now, once again, Virginia, which is coming up next year, you should have addendums or additions to your privacy policy specifically addressing the requirements of those privacy regulations. So that's kind of the high level of the presentation. Christine, we can open it up to questions if you have anything that's coming in, but essentially that's what goes into a sound privacy policy. Remember, this is not an end all tell all. This is not applicable to your business by every single means, but this is just a high level understanding of what type of stuff goes into a privacy policy and why it's important to have them in place.
Fantastic. And we have had some questions come in, and folks feel free to send more as we go if you have them. So we're talking a lot about, customer information, client information, folks coming to a small business's site or a nonprofit site. But would a privacy policy also be applicable to a business's employee portal?
So that's a good question, but the question is the employee portal, that is a separate software solution that you're using, right? So if you have an employee portal that you are, so the way to approach this is that software solution itself has a privacy policy, right? So the concern over there is that piece of software itself has appropriate protections in place through the privacy policy that they have published, that they are saying that they're using. Unless you built something yourself, which is usually unlikely. But if you're using something like a software solution for your employee portal, they have their own privacy policy. Where your responsibilities come into effect are and this is a completely separate subject, just for full clarity. Where your responsibilities come into effect is your own internal company policies and procedures. So every company should have a set of policies and procedures as to how they're handling the data of their employees and how they're protecting that information. Usually HR has something to do with that. As a small business, obviously, you don't necessarily have the means to have an entire HR department. However, there are certain things from a regulatory standpoint that you should have in place in order to protect that kind of information, like your employee information, because for all intents and purposes, that's a lot of sensitive data. Their names, their addresses, their social security numbers. So the software that you're using absolutely has protections in place. That's the assumption, and you should check on that. But on top of that, internally, you should have processes to make sure that any employee doesn't just leave that open on a computer, so anybody walking by can see someone's name and so on and so forth.
Okay. And on that same note, thinking of using third parties, when we're talking about customers, so lots of small businesses use Etsy, Shopify, other, websites that have their own privacy policy, and sales for the business go through it. Again, would the businesses be able to just rely on that site's privacy policy for the privacy policy and then have their own internal procedures and practices?
Really depends. Etsy has their own privacy policy. I think Etsy, if you have a shop up on their website, they have a sample privacy policy that you can put up on your shop. I think Shopify has the same thing that you could put up on your shop. Yes, as long as it appropriately aligns with what you're actually doing from a privacy standpoint, and it's hosted on Etsy.com or Shopify.com, like shop.etsy.com or whatever it is, that could apply. But one of the main things to understand is more practices as well, right? You're announcing to people what you're doing with their information. When you're using something like Etsy and Shopify, they have to have very strict, and I have seen privacy policies for Shopify. I've had clients that work with Shopify as a vendor to Shopify, and I've reviewed their policies and stuff as well. So we know that they have strict standards that they have to follow. So you have to hold them to that. But from internal standpoint, when you're receiving information about a customer, right? And a customer has entered their name and address and phone number for you to ship a good to them. I don't know how many of you have actually read Etsy's terms for you, because when you're signing up for Etsy, remember, you're clicking, I accept the terms and conditions, I accept the privacy policy, right? So take a read of what Etsy is asking of you, because Etsy itself is requesting or requiring you to have certain standards in place. So Etsy, on top of their privacy policy, they're also forwarding that liability through their terms and conditions to all of you that have shops on Etsy or Shopify. And those terms and conditions strictly state that you can't do this. You can only use your information for this. You're not selling information to a third party, so on and so forth. So take a read of those terms, because you will find some interesting stuff in there.
Okay. And when we're thinking about the opposite, maybe a business works with third-party vendors. Is it okay for the small business to ask the third-party vendors to not collect customer information, or to put in their contract terms regarding how long it's kept and how it's used in order to be consistent with the business's privacy policy?
Absolutely. You should have the right to do that. And a lot of the vendors that you're going to work with, you probably won't be the first person to ask for that or first company to ask for that. And if you are, then they have their own things to consider. But yes, you should absolutely work with these vendors and have a good understanding of what they're doing. Because just because this is going to make your life easier as a company, that's great. But it's all it's going to take is one thing to go wrong with their systems, right? T-Mobile just had a breach. Equifax just had a breach. All these, some of these point of sale systems have data breaches, and that revealed credit card information for millions of people. So when you're working with a vendor, it is within your rights to ask them for their privacy information, to require them to delete information after X amount of days, and so on.
Okay. And when we're thinking of, lots of businesses, of course, have websites, but they're starting to get back in person also. So, right. If a small business owner collects information on a customer in person, they write and sign up for the mailing list. And that mailing list is, through the internet, and it collects data on the customer when they read it, if they open it, where they are, how long they read it, what they clicked on.
Sure.
Because the person who signed up did it in person, does the business need to follow up by email to give them a copy of the privacy policy, or is having it accessible if they look for it in the footer of the newsletter or something sufficient?
That's a good question. It really depends on the applicability. So it depends on what you're using to collect this information, right? So if you're, I know real estate agents and real estate companies have specific software for this stuff. Like you enter the information that I'm interested in this house, and we'll send you more information because you came to the open house. It depends on what solution you're using to collect that information, because once again, every single piece of software that you use has their own set of terms and privacy policies, and all of them are requiring you to do specific things. So it's important that you read that, right? Now, as far as your privacy practices, I think that it's probably not realistic to print out and hand somebody a copy of the privacy policy, or have them click on privacy policy as they're entering information. But the solutions usually have like I accept checkboxes that you can use. Or when you do send them the marketing communication, yes, give them access to the privacy policy. Is that the end all tell all? No, that's a unique use case, right? We're talking specifically from an internet and website standpoint. But making sure people understand how you're approaching privacy is an important thing.
And this might seem obvious to you, I'm sure, as an expert in this, but when a small business owner is trying to figure out where to put the privacy policy on their website or their app, is there somewhere specific that it needs to be, or that it should be? Is it its own tab, its own page, a pop-up from the bottom, the top, something that takes up the whole screen?
Yeah, that's a good question. I mean, it should be its own page for sure. This is our privacy policy and clear. So data privacy laws and regulations require that, number one, the privacy policy be in plain English, so anybody can understand, right? Anybody can understand this is what we do from a privacy standpoint. It can't be a legalese like a contract like you generally see. And number two, it needs to be conspicuous. Like people need to be able to easily find it. So whatever that means, like on my website, you can clearly see across the banner at the top, the navigation menu, privacy policy is prominently placed up there. A lot of companies put it in the footer of their website, like this is our privacy policy. A lot of companies require, and it's usually for software companies, this is an absolute requirement. People need to actively click I accept to the privacy policy when they're entering their information. So the bottom line over here is there's no specific place, just make sure that it's conspicuous. Like make sure people can find it very easily.
Okay. So for small business owners that, have, or nonprofits, other organizations that have had somebody build their website for them, put in the integrations for any third parties they have, like Google Analytics or Google Ads, or
Sure.
for small businesses that have set up a website through a third party, like WordPress or Wix.
Right.
Maybe they don't know necessarily what data is being collected automatically. Is there a way for them, to kind of best understand, know, figure out keywords to look for?
Yeah, I mean, the best thing to do is ask whoever built it, right? That's really the best thing you could do. WordPress has a support feature. Wix has a support feature. You can just reach out to support, say, I'm building my privacy policy. I need to know what kind of information I'm collecting. If you're using a third-party, web developer or engineer or web designer, or even an outsourced team, they should have that information. Any reputable company does have that information available to you for you so that you can build out that privacy policy. So bottom line is there's no easy way to just say, here's a list, unless getting it from a third party, unless you specifically ask, like, tell me what exactly we're collecting over here. Do we have Google Analytics? Do we have an ad network built in? Do we have ad tracking cookies in here? Do we have web beacons? Do we have, are you receiving name, address, telephone number, email address, things like that.
Okay. Similar to that, are there standards for different types of information that may be collected through a site and how long they should be kept, or standards for how they should be stored? So, for example, should a name and email address be kept in the same manner for the same amount of time as credit card information?
Yeah, it's a good question. I mean, credit card information, that's tricky, right? So that's PCI standards. That's a whole separate ballgame. And you should be using a credit card processor for something like that who goes through that process. Yes, there are standards. Can I answer it on this webinar? No. I don't know off the top of my head, but name and email address. Different. Yeah, they should be there. Absolutely. So personal information and sensitive personal information are two different things, right? Personal information is name, address, telephone number, email address, something like that. Sensitive personal information is financial information, sexual orientation, even credit card numbers, social security numbers. That's sensitive personal information. Those are set to a higher standards. You have higher standards, higher liabilities. It needs to be better protected, and it's all based on the data privacy regulation that applies.
Okay, so thinking about data privacy regulations, that there's some stuff that just has to be more protected because of its nature.
Yep.
Does it make sense, or do you ever talk with clients about only collecting information that's absolutely necessary? So
yeah, absolutely. There is a standard.
What are you collecting, and why are you collecting it?
There's a standard for that, actually. So a lot of these data privacy regulations have a provision put in where it states that you're only collecting data absolutely necessary. Like there's a requirement of the minimum necessary information. So you're not collecting anything more than what you need to collect to provide services to company. So you don't need somebody's social security number if you're just contacting them for a restaurant reservation, right? Likewise, you don't need somebody's credit card number if you're not charging them for anything right off the bat. So all that being said, it's regulation dependent. It depends. It all depends on what you're doing, who you're doing it for, what you're collecting, how you're collecting it, how you're storing it, and so on.
Okay. So all of this great information, businesses are going through, making sure that their privacy policies are either getting put together or getting up to the standard they need to be. How often going forward, other than as needed, if something changes, should a privacy policy be reviewed or updated?
Yeah, that's a good question. So first and foremost, if anything with your product offering changes. So full disclosure, once again, my practice specifically works with software companies. And so I'll tell you from the standard of a software company, right? So software companies are consistently building new products. They're consistently releasing new editions or versions of whatever they've built. And based on that, a privacy policy should probably be revisited if anything changes as far as the information that they're collecting, the information that they're processing on behalf of their customers or users. So number one, absolutely, as things change, but that could be 3-4 times a year. Number two, in general, I think it should be visited at least every year, because once again, data privacy regulations are changing all the time. Requirements are changing all the time. New litigation they're in the court systems. Federal courts and state courts are seeing different kinds of privacy claims from people saying that, you violated my privacy by using my information and spamming me with emails. There are lawsuits like that. So based on that, I think at least on an annual basis, it should be revisited.
Okay, great. So for some of the small businesses and maybe some nonprofits that are listening, their websites are purely informational, right? If you want to contact them, it lists their email address, their phone number, directs you to a third-party site, any of those options. Is it conceivable that a purely informational site that collects no information would not require the organization to have a privacy policy?
It's a good question. I think at the very bare minimum, you should have a standard, like, that's the type of situation where a standard privacy policy can apply. But I don't think, once again, I don't know. I can't answer you in general. It's just very dependent on what's happening on that website. Even purely informational websites are still collecting data. Whether you believe it or not, your hosting provider is collecting data about whether you're using it or not. It's collecting data about where you're coming from, what you're hosting, and what you're looking at, how long you're on the website, so on and so forth. And even information-based companies, they still have analytics built into, because they need to know. That's metrics. That's part of a business, and whether you're a nonprofit or for-profit, you need to understand what your return on investment is. I think best practice is to have a privacy policy across the board. At the very least, with just basic information about what you're doing. Even if it says we're not collecting any personal information, that's fine, but have something there.
Okay, great. That totally makes sense. Let's see if we have any questions that we have not yet got to. Okay. So does it make sense for organizations that are small by general standards, but don't have any in-house expertise to contract with a third party to be their, data or privacy officer to handle this information? Is that an option? Are there experts that can do those types of things to streamline the process?
Yeah, there are all kinds of consultants to help with that. Definitely a possibility, definitely common, right? It's definitely something that is a service that is being offered out there if you Google around for it, and it is something that's relatively common, like a privacy officer as a service kind of thing. It's there.
Okay. On the other side, if a small business is collecting really just the personal information, not sensitive personal information, is it possible that, the owner or an employee that is not super sophisticated or tech savvy can manage the privacy policy and the information on their own?
I mean, it's hard to answer, right? You can, but what are the risks there? And that's an assessment that you're going to have to make, right? What if people use a dumb password for whoever's managing this, and that password's easily cracked? There's always bad actors out there that are trying to crack, and then if that's cracked, now you have a data breach. Now you're legally required to report to your customers and people that, hey, we have a data breach, and because somebody didn't put a right password to protect all the email addresses that we're collecting. And it's all dependent on the risk assessment that you make about who has access to this stuff. Ultimately, it's in everybody's best interest to protect this information and any such information, personal information, data privacy related information well. Protect it well, make sure it doesn't get breached, and make sure you're not held responsible for something.
Okay, that makes sense. We have one last question. You may or may not know the answer. If a business is going to, of course, go through everything they can to set up their privacy policy well, follow it, protect the information, get rid of it, or keep it as is necessary. But are you aware of any options such as insurance to offer some extra protection in the event that something goes awry?
Yeah, cybersecurity insurance is definitely out there, and most software companies have it, are required to have it based on their companies too. So definitely out there, look into cybersecurity insurance. Make sure that covers your specific use case, obviously. But yes, there are insurance options out there, and whoever your insurance broker is can give you those options.
And for businesses and nonprofits, depending on what you do, You might just by standard have it in your business insurance package, or you might be required to have it under contracts that you have with third parties or the government. So keep an eye out for that.
Yep.
Okay. That looks like all of the questions I have.
Awesome.
So any last remarks, final words for our listeners to take away, Shahad?
Sure. I mean, the main thing to realize over here is data privacy is becoming increasingly important, increasingly coming into the forefront. There are state laws. There's even a federal data privacy law that's in Congress right now with a committee going through review. And that all has to do with, it's not just, this is civil rights. This is not just, oh, you have an email address and it's been leaked anymore. Email addresses are connected to all of our accounts now. And that's why this is becoming at the forefront. So even if you think that this is a very small part of your business, it's not. It's probably significant. Yeah, and this all forwards as well to your vendors, right? It forwards to your credit card processors. It forwards to your reservation specialists or reservation software that you use. It forwards to your credit. It forwards to any rewards programs that you set up with any third-party provider or anything like that. So keep an eye on how you're collecting information, how you're using information, and let people know that this is what you're doing. And it's harder for a small business to have a full-blown security system, security procedures and policies in place. But try the best you can to have appropriate practices, have appropriate procedures and processes within your organization to protect this information, because the last thing you want really is a private right of action because someone did something wrong.
Okay, fantastic. And speaking of places updating their privacy policies, I just got an email from PayPal. They're updating theirs. So,
there you go.
They're always coming.
Always.
Thank you again, Shahad. Thank you to all of our listeners for joining today, or those who are watching the recording after the fact. In a minute, once we end the webinar, you'll be directed to a participant survey. So please share your thoughts on this webinar there, as well as topics that you're interested in for the Pro Bono Center to hold webinars in the future. And remember, if you would like to speak one-on-one with an attorney for free about your organization's legal questions, view our upcoming events, and check out our online resource library, you can do that by visiting lawhelp.org/DC/NPSB, lawhelp.org/DC/NPSB, NPSB for nonprofit small business. And with that, thank you again, Shahad, and thank you to everybody. I hope you have a wonderful day.
Thank you. Take care. Thanks for joining.